Hi, welcome back to Critical Philosophy. I'm Justin, and on today's agenda, a few bad Supreme Court decisions and how they still affect our lives. Stick around. In 1966, the Supreme Court had a landmark case in which they decided that the federal government could no longer impose poll taxes. It's called Harper versus Virginia State Board of Elections. Now, most Americans have no idea what a poll tax is, much less anything about them. They were a common practice. They were a tax deliberately designed and used to infringe citizens' right to vote. Today, we exercise our right to vote free of charge. That wasn't always the case. A poll tax was literally a tax imposed on Americans at the voting booth. The Supreme Court decided that it posed an unconstitutional burden on the exercise of a constitutionally guaranteed right. Supreme Court justices, being people, they are of course given to all manner of biases when interpreting the Constitution and exercising their, what I think is a completely illegitimate claim to something called judicial review. Now, at the outset, I should acknowledge I'm not a legal scholar, nor am I a historian. I don't claim any role for myself other than being a critically thinking American. I encourage you to do your own Google or AI research and come up with your own opinions reflecting your own critical thinking. My own analysis is the following. Judicial review is a concept that rests on very dubious legal foundation in the first place. It's a concept whereby the Supreme Court has taken on the responsibility of determining for itself whether federal or state laws conform to the dictates prescribed in the Constitution. The concept comes from Old English tradition dating well beyond the founding of America. It got started in American jurisprudence in the case Marbury versus Madison under Chief Justice John Marshall, who was also an American founder. Now, rather than taking too much time to formulate too many different arguments in one video about judicial review, all I'll say is that the Constitution doesn't leave it to the Supreme Court to decide for itself whether any law passed by the elected representatives of a people either should be interpreted and compared to the Constitution by it, nor does it leave to the Supreme Court authority to overrule or rewrite laws that are passed. Now, back to Harper versus Virginia State Board of Elections, the Supreme Court federally banned all state laws from levying a poll tax because that tax represented an encumbrance to the exercise of a constitutionally guaranteed right to vote. It didn't matter that poll taxes weren't steep, and the fact that they disproportionately barred blacks from voting was the main issue. Their thought was, if it costs too much money to vote, or money at all, then it stands to reason that a disproportionate number of impoverished Americans would simply choose not to participate in voting. That is, they would be forced to choose not to exercise a guaranteed right because of a government-mandated tax. Since a large number of those impoverished Americans were and would foreseeably be black, poll taxes were essentially used to deny blacks the right to vote. If a tax on voting represents an infringement upon one's right because it may hypothetically make that right too expensive to exercise, I believe it stands to reason that sales tax on ammunition, for example, represents, by the exact same logic, an infringement on one's right to bear arms. In the exact same way that a poll tax is unconstitutional, it is also unconstitutional for the government at any level to levy any tax on arms or armament, especially the permits that states like New York and Illinois and California require for citizens to arm themselves. All taxes associated with weapons are an infringement upon our right to bear arms, not to mention the erroneous limitations to, say, rounds in magazines. The right to vote has always had certain infringements. The right to vote is not imparted to a person based on their status as a legal citizen. It never has been. At one time, only land-owning white males of a certain age and financial status had the right to vote. Over time, and especially with the passage of the 19th Amendment, America has enfranchised more and more people with less and less stake in the outcome of the vote. The right to bear arms, however, has always not only been granted to individuals based strictly on their status as a citizen, but it is stated specifically in the Constitution to be a right exercised free from infringement. Just so we're clear, the definition of infringement is an abridgment or a shortening of. Any encumbrance upon the right to bear arms is by definition an infringement. This logic is the foundation of my point that all laws pertaining to the manufacture or sale of weapons is an infringement upon our right to bear arms. Thus, they are all unconstitutional. In my opinion, any weapon that can be imagined and then built ought to be able to be owned by private citizens. Any weapon at all. The United States military ought to have access to absolutely no weapon that a citizen doesn't have equal access to, except for maybe the purchase price. That means my position must be that Americans ought to be able to patrol their own skies with their own radar and fill those skies with their own stealth bombers, and be able to own and house their own Abrams battle tanks and all other military-grade weapons. Now, I realize that my view on our right to bear arms differs significantly from most folks, so let's hammer down. The right to bear arms goes hand in hand with one's right to self-defense. I've never heard anyone, no matter how far left or how pacifist, claim that a person doesn't have an inherent right to defend himself physically from harm. The right to defend oneself is not extended to a person in the commission of a crime. On the contrary, it is extended to a person who may be the victim of a criminal act. It's extended to individuals who opt to put themselves in harm's way for the sake of defending themselves or others from a villain. The right to self-defense isn't afforded to bullies, but to would-be victims. Let me ask you, should you ever be so unfortunate as to find yourself in the unenviable position of having to defend yourself or others from an aggressor, armed or otherwise, exactly which weapons do you not want to have immediate access to? Obviously, if you be just, you want to have superior arms and tactics to prevail. The right to bear arms doesn't exist so victims can have fought valiantly before their ultimate demise. The right to bear arms and the right to self-defense exist specifically so the just can overcome the onslaught of an aggressor. An aggressor may be fully armed and well trained in tactics. Wouldn't you want to be able to win the fight? You can only do that with superior arms and/or tactics. Just as the Supreme Court declared poll taxes unconstitutional, our founders rightly declared our right to bear arms was not to be infringed by taxes, legislation, or by any machination that would leave a just citizen vulnerable to attack from any foe, public or private.